The first rule of interpretation, as we saw, is the literal construction or the literal interpretation. And for all purposes of this chapter, I will call this as your most important rule, or the very first rule that has to be followed in any case of interpretation. So let's read what exactly this rule says. This rule says any words, phrases and sentences of a statute are ordinarily to be understood in their natural, ordinary, popular and grammatical meaning, unless this construction, or in other words this interpretation, leads to an absurdity of the content or object of the statute, suggests a different meaning. And this is also to be known as your golden or primary rule of interpretation. Now, what exactly do they mean by this? They are saying that when you are reading a statute, read the statute literally. Read the statute as it is, and do not give it any alternate meaning. Read it in according to its natural, ordinary, popular and grammatical meaning. So if you are confused about a word, open the dictionary, see the meaning of the word. Popular meaning, what exactly does this word mean in common language? Okay, so this is your simple rule of interpretation. Read it as it is, read it in its most popular, grammatical, ordinary meaning. However, there is a clause over here, there is an exception over here. They are saying unless reading it in its ordinary, natural and grammatical meaning could give rise to further absurdity or cause more confusion, or be interpreted in such a way which is the exact opposite of the object of the statute. So let's repeat this again. All words in a statute or all sentences in a statute have to be read in their natural, ordinary, grammatical and popular meaning, unless a reading of the same leads to further absurdity, confusion, or is the exact opposite of the objective of the act. Okay, so we will see what needs to be done if it falls under the exception rule, but up until this point we are referring to the literal rule of interpretation, and that's exactly what the court has held in the case of Nanda Prakash Vora versus the state of HP. Here they are saying that interpretation should not be given which would make other provisions redundant. The words natural, ordinary and power are used interchangeably, that is not power, my bad, this is the word popular, are to be used interchangeably. The courts must use the grammatical or the literal meaning except when the words are technical, because then the technical words will have technical meanings. So in short, this interpretation is saying give the most fair, effective and straightforward meaning to your sentence. Now what happens if you fall under the exception? That is, you are following the natural, ordinary, grammatical meaning when you are interpreting the word, but then such an interpretation is giving rise to further confusion, or it is going against the very objective of the statute itself. That time they are saying that in the state of HP versus Pawan Kumar, they are saying that if the plain and literal meaning causes any repugnancy, absurdity or inconsistency, then the court can depart from the plain and literal meaning and modify the words. Okay, so as a result of this exception, the power is being given. The power to modify is given to the court of law. This is when only if it gives rise to repugnancy, absurdity or inconsistency. So it is clear that you have to prove this in a court of law, that if I read this in a certain way, it is going to give rise to absurdity. and only if the court believes that yes, this kind of interpretation can lead to further confusion and absurdity, only then will the court go ahead and modify the meaning of the words. And so this is your literal interpretation or your literal construction under your interpretation of statutes chapter. So when we look at the literal interpretation, we have to understand that this is the most cardinal rule of interpretation to be followed. However, it must also be understood that sometimes when the law is being read, or when a provision of law is being read, so it can give rise to two or more meanings under law, meaning 1 as well as meaning 2. Now both meanings are understood from its natural, ordinary, grammatical and popular meaning, and both meanings can give effect to the statute. Both meanings can be good in law, and both meanings, when read in accordance with the situation at hand, could have a valid scenario. So what should the court do at that point in time? The law is saying that go with that meaning which advances the remedy and removes the mischief. What do I mean by removes the mischief? Removes the problem in society. Okay. Now, am I still talking about literal rule of interpretation? In a way, yes, but we're also moving into the next topic, that is your Hayden's rule or your mischief rule. Now, when exactly should we use mischief rule? Because we've understood where we need to use literal rule of interpretation. It is the very first principle of interpretation that must be followed by a court of law. However, while doing an interpretation, you might come out with 2 or more meanings under law, all of which can be valid. So therefore, the courts are expected to go with that meaning which helps to advance the remedy that is provided under that statute and remove the mischief for which the statute came to remove. And that is what the mischief rule or the Hayden's rule comes and says. It's saying that the law must be interpreted in such a way so as to suppress the mischief and advance the remedy. So the whole point of this is that every law is made with a certain purpose. That is, we do not have laws which are simply being passed by legislature. Every law comes out for a specific purpose, and that law is now it's implemented and interpreted across our country. So when we say that a law is coming out to cure a mischief, then it must be understood that every interpretation given by the court of law should be moving towards removing that mischief from society and not helping it grow. And that is why they are saying the law must be interpreted so as to advance the remedy and suppress the mischief. Now, the mischief rule is applicable only when a particular rule is ambiguous and capable of different meanings. So, we always go with that meaning which helps to suppress the mischief and advance the remedy. Now, where exactly did this rule of interpretation come from, or where did this rule evolve from? This rule evolved from your Hayden's case, wherein the court looked into multiple factors. They tried to understand how exactly a rule of law must be implemented, and so they asked 4 questions. What were those 4 questions? First and foremost, they asked, what was the common law before the implementation of the act? That is, before this law came into force, what was the existing principle on that law? Was there a custom? Was there a usage? Was there some kind of activity which is just accepted by all the people? Was there any common law? Or was there any principles in place which were to be followed generally as the rule of law? Then, what was the mischief that and defect for which that common law did not provide? So, say for example, we have a law governing nuisance in our country. Okay. the Nuisance and Certain Public Offenders Act. Please understand that this is a purely hypothetical law that I am giving to you all, and such a law does not exist. Okay, so let's say this Nuisance and Public Offenders Act of 2025 has come into effect. Now the question is, before this law came, what was the common law principle which existed? That is, was there any existing principle on nuisance? Was there any existing law governing public offenders? What exactly is a public offender, etc.? All of these, was it governed by a common law principle? Now the answer is, if it was yes, then what exactly was that common law, and that common law did not provide for? That means, if the common law was sufficient to govern that matter, then it's safe to say that our parliament would not have come out with this law, because there was no need to pass a law. But then, here we can see that the common law existed, that is, a body of principles existed, but it was not sufficient to curb the Nuisance and Public Offenders Act and public offenders in our society. So the next question is, what was the mischief and defect for which the common law did not provide? Then, what remedy does the parliament give for resolving the existing mischief? That is, under this law, what is the remedy provided under law? Okay, and finally, what is the true reason for this remedy? Why exactly did they come out with either punishment in the sense of, did they come out only with a fine, or did they also come out with an imprisonment term? So it is best interpreted this way, as so as to understand what exactly was the intention of the legislature at the time of passing this law. The next principle that we're looking at is your rule of reasonable construction. So when we look at the rule of reasonable construction, it doesn't have to be followed immediately after that of the Hayden's rule. Okay, the rule of reasonable construction is to be read separately while interpreting statutes. So let me just give a clarification before we move on to the remaining part of this chapter. While I initially said that you have to follow the literal rule of interpretation first, and then only subsequently go into the Hayden's rule, it doesn't apply to every single rule of interpretation that way. There is no classification or criteria wherein, okay, literal rule not applicable, Hayden's rule not applicable, reasonable rule. If reasonable rule is not applicable, then rule of adjustum generis. It doesn't go like that. Okay. However, the very first rule that anyone has to ever apply is going to be the literal rule of interpretation. And since literal rule is eventually read with your Hayden's rule, it is read after the other. Whereas the rule of reasonable construction can actually be read alongside the literal rule of interpretation. So what exactly is this literal rule of interpretation saying is that it is a slight modification of the literal rule of interpretation. It's saying that first and foremost, when you're looking at a law, it must be construed sensibly and reasonably, in the sense that sometimes when we apply the literal grammatical meanings of words or the literal popular meaning of the word, then it actually gives rise to more confusion, or more specifically, the courts may not be able to implement this interpretation in light of the object of the statute. So let's say the objective of the statute is to enhance consumer protection in the markets. But then, while interpreting one particular provision, it's going in the exact opposite direction. It is saying, it is giving more importance to that of the sellers and rather giving rise to more nefarious activities conducted by certain sellers in the market. Now this is just an example. So what the law is saying is that regardless of how you have to interpret it, literally or to suppress the mischief, advance the remedy, ultimately the law must be read reasonably. And if when we are reading it literally in its popular meaning, grammatical ordinary meaning, If it gives rise to more confusion, or more specifically, the court is unable to reconcile that interpretation along with the object of the statute, then the courts can actually depart from the original grammatical meaning and give effect to that word. So that is what they're saying. It is the duty of the court to make a law operative and effective. Because remember, we're going back to our original understanding that Parliament has made the law. And Parliament has made the law in such a way so that the judiciary should be able to interpret the law. However, if the law was passed a really long time ago, we will not be able to go back for clarification. And so the duty rests on the judiciary to be able to interpret the words in a certain way so as to understand the will of the legislature. And hence, while doing interpretations, the court must always try to give effect to the law. Let's say while reading a law itself, there is a chance that if it is to be read in its literal, ordinary and grammatical meaning, then it just gives rise to it is unreasonable while reading it that way. Then the courts must try to make it effective or operative in some way. Because the court cannot say, okay, this law does not make sense, I will not follow this law, give me another law to choose from. This is not a choice of which law applies to you over here. One law is applicable for this particular purpose, and the courts must try to give their best interpretation or effectiveness to it. And they're saying a construction must be rejected if it causes hardship, serious inconvenience, injustice, or absurdity. So, where again there are multiple interpretations that come up, it is to be clearly understood that whenever there's a confusion, the court must give effect to the most reasonable interpretation in the circumstance presented before it. So, if you see the rule of reasonable construction, it follows this legal maxim known as utre magis valium quam pariat. I'll repeat it again, utre magis valiat quam pariat. The rule of reasonable construction, in the sense that the statute must be read sensibly and reasonably. So let's look at the case law over here. In Tirat Singh versus Bachitar Singh, they said that it's only when the language of the statute in its ordinary grammatical construction leads to manifest contradiction in the purpose of the law, or to some inconvenience, absurdity, hardship, or injustice, which may not be a very intentional activity, a construction may be put upon it which modifies the meaning of the words and even the structure of the sentence. So this is your most important part when it comes to your interpretation. They can move away from that particular sentence or alter the sentence, add in words or remove words also, so as to give a proper and reasonable or sensible way of giving effect to this law. In Kanwar Singh versus Delhi administration, the court said that it can depart from the dictionary meanings and it will give a meaning which advances the remedy and suppresses the mischief. And finally, in RBI versus Peerless General Finance, the court said, read the law as a whole. Discover what each section, clause, subsection, subclause, etc. is meant to say so as to fit within the ultimate object of the entire law. It must not be read separately and it must not be read separate from each other. So, each section, each clause, phrase, provision has to be given effect to in light of the objective of the act. And this is only a rule of reasonable construction. Now, we saw in the reasonable construction principle, clearly it had said that it is the duty of the courts to make a law effective and applicable. So, in the sense that the court must try to make the law an operative law. And so, in line with the same reasoning, we come to the next principle of interpretation, which is known as the harmonious construction. Now, it may be the case where multiple statutes or two statutes and statute 2 are clashing with each other. That means the provisions of statute 1 cannot be read with the provisions of statute 2, and more importantly the provisions of statute 2 cannot be read with provisions of statute 1. Or in one statute itself, say subclause A cannot be read with section 2 clause B, because it will not make any sense. So let's say, for example, what do I mean by this? This is purely an example purpose which I am giving you over here. There can be a law, again this is an example. Let's say there is a law prohibiting e-cigarettes in the country. Now, what is the objective of this law? The purpose and objective of this law is to prevent health deterioration in the the purpose of prohibiting e-cigarettes was to prevent health deterioration or health problems and to prevent the sale of harmful substances. So it could be said that e-cigarettes actually uses a substance which could be harmful to your respiratory system. Now this is the objective of the law. Again, please remember that this is an example only, and that such a law to a certain extent it does exist, but we will look at it from only this example point of view. Let's say, for example, that in this law we have a section number 3, clause A, which says that the sale Okay, so let's just read this example in a little bit of detail. We are now looking at a law prohibiting e-cigarettes. The purpose of this law is to prevent health deterioration in the country and to prevent the sale of harmful substances. And that's exactly what section number 3A is coming out and saying. It's saying that the holding, acquiring, selling or dealing with e-cigarettes is prohibited, and such an activity is to be considered as void, or such agreements are to be considered as void. However, section 3 clause B is further coming out and saying, notwithstanding anything contained in A, that means you disregard the provisions of A for now, existing stock of e-cigarettes can be sold. Okay, so this provision outright may look like it's okay, it's all right, because see, e-cigarettes are in circulation, and what will the stockholders of e-cigarettes do? They will need to sell their property somewhere, right? Now just think about it this way. if we are prohibiting the holding, acquiring, selling or dealing with e-cigarettes, but then subsequently we are also coming and saying that if you have some existing stock, then you can sell it out. Now just imagine, from a retailer's point of view, he may have maybe 10 to 20 e-cigarettes in his shop, or let's say a total of 50 pieces in his shop as a matter of a retailer. Now does this provision apply only to retailers? No, it can apply even to wholesalers, distributors, manufacturers. Manufacturers will be holding 1 million pieces. Each manufacturer will be holding, on any good day they may be holding 1 million to even 5 million pieces of e-cigarettes. So that is also in stock. So that means it would allow the manufacturer to sell his existing stock in the market, and further anybody who acquires the stock, because they are only saying the action of acquiring or even selling. So if the manufacturer does not exactly sell it, many things can happen in the black market transactions, where you are authorized to sell your stock, but you are not authorized to sell anything which is manufactured, which does not make sense, because ultimately it is the action of selling. Ultimately it's the action of buying from another person, even though you're classifying that as existing stock. Now what if the manufacturer decides, no, I will classify all of my existing stock as even including my raw materials, because with the existing raw materials I can make another 50 million pieces of e-cigarettes. Now that can also be his stock. Then once it becomes his stock, he can sell his existing stock, which will continue the flow of e-cigarettes in the market. So don't you think this is going against the very purpose of this law? Apart from going against the purpose of this law, we can see that these two provisions by itself are clashing. On one side it's saying that no person is allowed to hold, acquire, sell or even deal with e-cigarettes. But then the subsequent provision is coming and saying, just to clear your existing stock, you can do all of the above. So this is what we call as a clash of a law. That means two sections or two different laws also are or cannot be read together. Because if the law is given, if the court tries to give effect to section 3 clause B, then it would violate the very provision on the purpose of the law itself. Whereas if the court gives effect only to section 3 clause A, then existing e-cigarette manufacturers will be harmed. Ultimately, is that with the objective of the law? Yes, section 3 clause A alone is to be read with the object of the law, because section 3 clause B is actually going against the provisions of the law. So let's keep this provision in mind before moving on to the principle of harmonious construction. They are saying that when the court is interpreting a statute, it must be done in such a way that the act as a whole serves a useful purpose. It may be possible that certain sections cannot be read together or are contradicting each other. At that time, it is very important that the court should reconcile the provisions of this act, and an effect should be made to give effect to both the contradictory provisions. So over here, in the example that I have given, section 3 clause B can be interpreted in such a way so as to say that all the existing stock of e-cigarettes should be disposed of within the next 1 month. And then you can apply both of them together, both the provisions together. Because obviously there will be the manufacturers who will be suffering a great loss if there is a sudden dumping or there's a sudden prohibition of e-cigarettes. So if this provision, section 3 clause B, is applicable within a period of 1 month or 30 days time, then this provision is a little bit more reconciliatory, because it's saying that within the next 30 days you can move your stock, but apart from that, all activities relating to e-cigarettes are banned under law. Okay, so this is what we say, that the court must try to reconcile and give effect to contradictory provisions under the same statute. So therefore, both provisions are given effect to, and a head-on clash is basically avoided. So what exactly is this harmonious construction? You are harmoniously reading two provisions together, and that is what harmonious construction means. So if you have to read this again, the harmonious interpretation is comes into play when there is a conflict between various provisions of law. It may be within the same statute itself, or it may be two separate laws may be clashing with each other, and the court is required to harmoniously interpret both of them so as to reconcile it and give effect to both the provisions of the Act. This is to ensure that a head-on clash is avoided, and more importantly, the provisions of the law are given effect to. So let's just look at what was held in the case of Messrs. New India Sugar Mills Limited versus Commissioners of Sales Tax, Bihar. They said that the provisions of each law must be in harmony with the object of the statute, and the provisions of the law must give effect to or promote the object of the statute. This is what your rule of harmonious construction comes out to say. So then let's look at what was held in the case of Venkataramana Devaru versus State of Mysore. I'd like you to please note that this example that I gave is not related to the above case law, and hence I am removing this for the time being. Let's look at what was held in the case law itself. The case law refers to a constitutional law provision relating to your right of religion and belief. Okay, so Article 26 Clause B states that every religious denomination has the right to manage its own affairs. What do you understand by manage its own affairs? Managing its own affairs can mean multiple things. It can provide entry criteria. It can specify a dress code. It can specify timings the temple would open, or even the fees to be collected. Certain temples do a lot of community service. So what kind of community service will be provided? What kind of events will take place, etc. So this is what it means to manage the affairs of a religious denomination. So this also means, like I said, entry criteria. That is, who and all can enter the temple premises. Are women allowed to enter the temple, or men, are they allowed to enter the temple? Or what is the dress code that you should be wearing at the time of entry? Because there are some temples who have certain dress code restrictions. I know in one temple men are not supposed to wear their t-shirt, and they should be bare chested, whereas women are required to wear a sari or a churidar, etc. There are some gurudwaras, which is not a Hindu temple, which requires women to cover their hair when they enter into a temple. So these are some religious requirements or requirements of religious institutions. Okay, and that is what Article 26 Clause B is coming in saying. Every religious institution, every religious Hindu denomination every religious institution has the right to manage its own affairs. However, when we have Article 25 Clause 2 Clause B, there is a restriction purely on Hindu religious institutions. They are saying that Hindu religious institutions of a public character. That means public character means it is being run by the government of India. So a small point to note that most of our religious institutions, that is the Hindu temples, are actually being governed by the government of India. And it's saying that all of these institutions must be thrown open to a general public. Okay. So what is the problem over here? It is a temple. Temples are accepting and inviting of everybody, but it must be understood that even temples have certain restrictions as to who is allowed inside and who is not allowed inside. Now, like I said, some temples are restricted to women. because women are not supposed to enter a temple either on certain days or until crossing a certain age. Then certain people are not allowed into certain temples, whereas they are allowed into other temples. Okay, so this is the case with most Hindu religious institutions. But then the law is coming and saying that is not of any matter. If you are of a public nature, that means if you come under the government, then you are required to open your premises to every person who comes. Now this is directly contradicting the previous right, that is the right to manage its own affairs, and that is why they said that these two provisions are contradictory in nature. However, the courts ended up harmoniously interpreting these two provisions together, and they said that okay, all Hindu religious denominations must be open to all classes of Hindus. They may put restrictions on certain other religious to certain other religions or to foreigners, etc. But at least to Hindus, the temple should be open to all classes of persons. And this is how the court ended up harmoniously interpreting the provisions of your Article 26 Clause B and your Article 25 Clause 2 Clause B.